Swayam Prabha. Digital India. Educated India.
Namaskar friends, welcome to SwayamPrabha DTH channel. My name is Dr. Parikshit Sirohi. I am Senior Assistant Professor in Faculty of Law, University of Delhi. As part of the course on cyber crimes, this is the 9th module, the 9th lecture, and here we are going to deal with cyber pornography. Friends, these are the topics that we are going to be discussing as part of this lecture over the course of the next 1 hour or so. We are going to be discussing about pornography and cyber pornography. Friends, pornography is not something which is new. It is not something which has emerged only with the advent of the internet. It is just that with the advent of the internet, it has become very easy, it has become very simple that and it is very easy to disseminate porn, it is very easy to create porn, it is very easy to have more and more graphical porn in that you can have live images, you can have movies, you can have animations, you can have clips which were previously not the case, easy to circulate, easy to create and easy to disseminate. So the challenge is increased manifold. Then there is what kind of a problem are we actually facing? Friends, the questions of morality, whether what is decent and what is indecent, morality, subjectivity, these are subjective issues. What one person may call immoral, another may not. So how are we going to be grappling with these aspects? What is the experience of other countries in regulating and curtailing the menace of pornography? This is a serious problem. It can completely damage and destroy entire generations if we are not careful, friends. The substantive law in India dealing with pornography, previously it used to be section 292 of the Indian Penal Code. Thereafter, now the Indian Penal Code is replaced by Bharatiya Nyaya Sanhita, which has come in December of 2023. So, in the new law, this is provision is now 294 in the Bharatiya Nyaya Sanhita. Other than that, we have in the special law, which is the Information Technology Act, 3 provisions which are dealing with pornography. One is dealing with publishing or transmitting obscene material in electronic form. One is in publishing or transmitting the material in pertaining to sexually explicit act. And then the third is publishing or transmitting material depicting children in a sexually explicit act. So we can say this is a more general provision, this is more specific, and this is even more specific. This is just a way I am telling you so that you can remember and understand this. And of course, in the substantive law, we already have 294 of the Bharatiya Nyaya Sanhita. 2023. So, friends, there is also a proviso to this particular section 67B. We will be studying about that proviso also. So, these are the topics that we are going to be covering, friends. Friends, technology solves so many of our problems. This lecture is coming to you through technology. I am sitting at a remote location and I am recording this lecture, which is going to be broadcast on DTH TV. So, friends, the inherent capacity of technology to show absolutely scant regard for legislative and judicial efforts to regulate the human behavior. So, as lawyers, as policymakers, as scientists, we may be making efforts to regulate the human behavior, but that may not always be possible because technology is very fast and law unfortunately has to always catch up. So, science is always engaged in expanding the boundaries. the confluence of two very important significant technologies, computer and telecom, has led to the creation of internet. So the boundaries are being pushed all the time, and law struggles to define these boundaries, or in some cases redefine these boundaries. We create new laws, we amend existing laws, so that we are trying to keep up with technology. There are so many benefits of technology, friends. There are so many benefits of internet, friends, but the same reasons for which the internet has benefits, the same reasons are the ones which the pornographers, the persons who want to create and circulate porn, they are making use of that. The internet is a medium which is which offers anonymity, which offers fast dissemination at very little cost, very cheap cost. So this is the pornography takes advantage of the anonymity offered by the internet, friends. Friends, now comes the question of morality. We repeatedly say that law and courts and lawmakers and implementers of the law, they should not be questioned, they should not be concerned about questions of morality. They should not be concerned about questions of ethics. Rather, they should be concerned about questions of law. Is it illegal? That is the question which a judge or a magistrate or a law implementer has to should answer. But sometimes it is not as simple as that. There may be certain things which may not be illegal but may be immoral. So morality is a very opaque, very rather I would say subjective kind of a word. What is moral in one area may be immoral in another area. So for example, in many parts of India, there is a custom that people get married to their cousins. People get married to their maternal uncle. In another parts of the country, they will call it a degree of prohibited relationship. They will call it incestuous relationship. So these are just questions which may be moral in some areas and immoral in another areas. Again, certain countries, certain cultures, they absolutely frown about any kinds of intermingling with persons of the opposite sex, whereas in other countries it is considered unhealthy if this is not done. So and similarly the moral standards may be very different in villages as compared to metros, or metros as compared to smaller towns, or smaller towns as compared to bigger towns. So these are the certain aspects which, you know, pornography, the question mark is always there, especially in countries like US. The moral standards come in the way. Moral standards are very fluid. What is moral today may become immoral tomorrow. What is immoral tomorrow may become moral few days later. And again, it varies according to geography. Let me give you another very simple example, friends. Till a few years ago, it was perfectly natural for people in India to defecate in the open, because they have been doing so for generations. But now open spaces are shrinking. Now the population in urban areas is increasing very fast. So now if people defecate in the open in so it the fecal matter may not get decomposed so easily and may create various problems. So that is why now defecation in the open is frowned upon. In fact, laws have been made to prohibit it. So the morality changes with time, law changes with time, law influences morality, morality influences law. As lawyers, as law academicians, we are social scientists. So we understand that law leads to social transformation and social transformation leads to change in law. Now the case of pornography is complex, because there are subjective parameters like obscenity and indecency involved. So now again, obscenity. Somebody may say that wearing clothes of a particular kind is obscene, whereas somebody else may say that no, this is perfectly okay. Wear whatever clothes you are comfortable in. Similarly, the issue of what is decent and what is indecent. So what I am trying to say is these parameters are very fluid and they vary according to the time, and according to the place. So the problem with internet as a transient medium, the pornography can pass through internet, which is a very transient medium, is enough to make draftsmen despair, lawmakers lament, and magistrates mourn. A beautiful line which I read somewhere and I thought I must include in my talk. It is the problem becomes so complex Pornography itself is enough to give people a headache what to do with it, how to curb it. On one hand, it is so wrong. On the other hand, somebody will say, no, it is you are just being moral police. You are being too prudish. With the advent of internet, the problem has become so large in scope that the draftsmen, the people who are making the drafts of the policy and the law, they will despair. The lawmakers will say, now what do we do? They will lament. And the magistrates, the judges, they will mourn. So pornography is not fundamentally new. It is something which has already been in existence previously. It is like most internet crimes. It is new crime in old bottle, new wine in old bottle. So it is just that the distribution has been facilitated because the internet is a medium which makes the distribution much more easy, much more cost effective, and much more fast, friends. Friends, now is the nature of this beast called pornography. I am calling it a beast because it is something which is enough to damage the future of entire generations, friends. It is like drugs. Initially the people who are peddling it may give it to you for free so that you are addicted to it, and then you will want it at all costs, and that is why before you realize you become addicted to it. So in our society we will come across people who are well placed, people who are in good positions, but many a times we may know that we may come to know that they are addicted to watching this kind of stuff, which is certainly not in the confines of law, or which is certainly not confined in the confines of law in a traditional society like ours, friends. There is no qualm in saying that we are basically a traditional society. So the scholars are categorizing criminal behavior involving computers into three major categories. First of all is the crimes which can be properly so called, and the offences like hacking, which you have seen previously. The computer and network is absolutely essential to carry out such a crime. Pornography does not fall here. The second category is computer assisted crime. Now here pornography is a classic example of this phenomena. The second category, friends. The computer is a medium. Computer is assisting you to carry out this activity which you were carrying out even previously with before the advent of computers, before the advent of internet. People were still carrying out indulging in pornography through magazines, through pamphlets, through books. People were carrying out these things. There are so many magazines which peddle pornography. There is this one, Debonair, Playboy, so many of them. They were in publication even before the cyber world or the internet or the computer world came. So it is not as if this is a new invention, friends. So this is a computer assisted crime. The crime can happen even without computers, but now with assistance of computers, it has acquired a whole new phenomena. Friends, the third kinds of crime which are involving computers is where usage of the computer is incidental. So for example, the computer may have been used to carry out some fraud or some other wrong activity, illegal activity. The details of that activity have been lodged onto the computer hard disk, and this hard disk can be retrieved. This server information will be there on the server. It can be retrieved and used as evidence in court regarding committal of such an activity. So here again, if somebody has been viewing pornography or somebody has been circulating pornography, the information will be there on his system, on his server, and it can be retrieved later on, friends. So pornography classically falls in this category, and evidence of pornography can be obtained from here. So friends, it is not a situation where no law applies. No, law is available, but it is a case to establish which law applies. It is not a case wherein no law applies. Rather, it is a case where you have to figure out which law applies, and then you set into motion the whole process of applying the law. So friends, it is like in medical science, the diagnosis is difficult. Once the diagnosis is established, the treatment becomes very easy, friends. You may have gone to a doctor, and typically when you are suffering from fever, the doctor will write pyrexia of unknown origin. Pyrexia in Latin means fever. So he is saying unknown origin. He does not know what has caused the fever. Fever is not the disease or the problem. Fever is the manifestation of the problem. So there is some infection in the body, and to fight the infection, the body is using the white blood corpuscles and the red blood corpuscles, and the WBCs are creating the fight, and that is why the temperature in the body is rising. So the fever is the manifestation. So similarly, friends, once the doctor has a diagnosis that fever is being caused because of cold, fever is being caused because of the allergy, or fever is being caused because of some more serious problem, then the treatment becomes very easy, friends. So similarly here, this is not a case where no law is available, but you have to find out which law. You have to find out the diagnosis and then apply the law, friends. The authorities face a lot of difficulty in answering this question. That is why I gave the example of medical science, where diagnosis is difficult and treatment is easy. So similarly here, finding out which law to apply is the one which is difficult. Authorities face difficulties because the internet is always creating newer and newer problems, newer and newer aspects of technology, and you have to find whether the existing law is good enough, or whether you need to upgrade the law, you need to enact some new law, you need to amend the law, and the same is the case in the challenge that is posed by cyber porn. Friends, since the internet is boundaryless, since the internet does not have any geographical boundaries, any territorial boundaries, any political boundaries, it is transnational in nature. We have seen this repeatedly. So the same problem you have in cyber porn. Now, what do we do if the porn server is located outside India? How do we prosecute such a person? Because our laws are territorial in nature. If somebody is sitting in another country X and circulating or creating cyber porn, through the internet, we will not be able to prosecute that person in India. So those are the challenges which we have to face when it comes to cyber porn, friends. Friends, what is the potential for harm? There is immense potential for harm, friends. The technology facilitates so much of commercial activity, so much of impetus to business. And pornographers also unfortunately are tech savvy, and pornographers also unfortunately have not shied away from taking up the internet as a business opportunity, friends. Huge amount of porn is available on the internet. The huge amount of porn is created, content is created and reproduced quickly, cheaply. Previously, with the advent of computers, this was started to be done through floppy disks, through hard disks, later on CD-ROMs, and now internet. So with the advent of internet, the negligible cost that was there to use media like hard disk or CD-ROM or DVD or floppy disk, that has also gone out of the window. Now internet, virtually at zero cost, the porn can be sent from place A to place B, and huge amounts of it can be sent via the internet, can be put up on a website, can be mailed, can be sent to a bulletin board. There are so many ways to do this, and technologists and people who are dealing with porn, there are huge big companies, there are corporates who are dealing with porn. It is big business. Unfortunately, because in many parts of the world people are sexually repressed, so they resort to viewing porn, and so it becomes an outlet for their sexual frustrations, energies, etc. So friends, there is so much of new types of porn which has come up because of the internet. So previously you were only seeing pictures, the still pictures, which the camera captures only a still picture, like you take a photo of your friend or your school garden or your college garden, that is a still picture. Then there is a motion picture wherein it is a video, moving picture. So previously the porn that was available in the form of books or pamphlets or even the floppy disks, etc., it was only the still pictures. Now not only pictures, still pictures, not only images, but full motion video clips are available, friends. They have sound, they have full movies that are available on the internet. Friends, sites like YouTube, etc., will be very responsible, and any kinds of content, forget porn, even if it is any kind of content which is deemed to be improper, I am using the word improper, even that will be removed. As an exercise, friends, go onto the web and on your YouTube channel, you search for a particular clip wherein this film star Demi Moore, there was a very famous scene wherein Moore, the actress, is crossing and uncrossing her legs in this movie called Disclosure. I think this came in the early 1990s. So, friends, this particular clip from Disclosure will not be available. Instead, you will see a notice on YouTube which is put up saying that we are sorry, pursuant to a Digital Millennium Copyright Act notice, this video is no longer available. This video has been removed. So, inappropriate content, responsible websites will never allow it. Forget about porn, even inappropriate or improper conduct, content which has been flagged will not be available. Just as there is one responsible YouTube, there are millions of irresponsible sites which are only and only hosting porn, various kinds of porn. The worst kind of porn is porn which involves children. Children indulging in sexual activities with other children, or even worse, children involved in sexual activities with adults. So, which is horrible, but you will find it on the internet. The latest trend that is there is sex chats, wherein a user is logging in through an internet relay chat and indulging in various sexual activities with the other person, maybe using the camera, maybe not using the web camera, but just typing, maybe using audio. So, all these things are available. There are interactive live sex websites wherein you can either the user can go and see the other person performing various kinds of sexual activities on demand, or the user can simultaneously indulge in sexual activities along with the other person. Of course, none of this is for free. There is large amount of money which changes hands, and such persons are, by the way, called subscribers. Just as you are a subscriber for a mobile or a subscriber for a DTH, people subscribe and pay for these kinds of things. So, friends, whenever such activity is taking place, the person who is the subscriber, the end user, he can view all these activities on his computer monitor or mobile phone. He can save it. He can print it if he wishes to take a printout of a picture or a text. He can transmit it to somebody else, and thereby more and more porn gets created, more and more porn comes into the ecosystem. There is a complete porn economy, so to say. Discouraging the reproduction of this material becomes very difficult for law enforcement, simply because it is reproducing so fast and reproducing in complete anonymity. You don't know who is creating. Friends, previously the forfeiture was a very significant weapon in the hands of the law enforcement. So, supposing somebody is selling books or somebody is selling magazines which have this kind of content. Supposing you are stealing 10,000 magazines or 5,000 or 500 magazines. So, suddenly the publisher is going to feel the loss, because these magazines will not be cheap. They will not be cheap because the same cost of printing has to be realized from fewer people. A mass magazine will cost, let's say, 30 rupees, maybe India Today will cost 30 rupees, mass magazine, because there are thousands and thousands of people reading it. Whereas pornographic magazine like Debonair will probably, the same number of pages, the same kind of printing will probably cost 500 or 1000 rupees, because the number of people who are buying it is much lesser. So, if the number of copies that are seized is running into hundreds and thousands, obviously the publisher will face economic loss, and that is a very significant weapon in the hands of the law enforcement. But now, when the reproduction is happening so fast, uncontrollably, just like amoeba reproduces, just like rabbits reproduce, at that kind of pace, the reproduction is happening. Forfeiture is of no use, because the copies are being made, backup copies are being made, it is already available on the hard disk. If somebody seizes the DVDs or CDs whereby the pornographer is selling them, but the pornographer can make 10,000 other CDs. The only thing which he loses is the cost of the CD, which is probably 50 rupees or 30 rupees, which is nothing. So all the advantages of internet work to the advantage of the pornographer. The easy to use nature of internet, the fact that internet is having wide prevalence, the democratic nature of internet, the anonymity offered by the internet, this is all working to the advantage of the pornographer. So should we stop using the internet? No, the answer is no. It is just that we have to develop our law, we have to develop our law enforcement, we have to sensitize our society to such extent that the job of the pornographer, the cyber porn person is becoming more and more difficult. So the main challenge is how do you discourage the reproduction? How do you, now that forfeiture is not a weapon, how do you proceed? What kind of other remedies do you have? In India, we have blocked so many of these porn sites, but does that deter the persons who wants to go to these porn sites? Unfortunately, no. The persons who are creating the porn sites, they approach these persons and they offer them proxy servers through which you can reach the website. So now governments have so many other things to do, but the people who are in the business of porn, they have only this one particular target, so that they have to ensure that their business of porn does not suffer. So they will keep coming up. So it's like in the Hindi movies that you see, previously you would find that the thief has a bicycle and the police are chasing them running. Then the police starts coming on bicycles and the thief has a motorcycle. Then the police start having motorcycles and then the thief starts having the jeep. Then the police starts having the jeep and then the thief starts having an SUV. Today police have SUVs and the thief has even better SUVs. So supposing the police have Scorpios, the thieves have Fortuners. So that is unfortunately the ground reality even in the cyber world. The law enforcement, the enforcers are always one step behind, and that is the reason why these people who are creating these cyber porn and other things, their business interests are so well entrenched, their knowledge of technology is there, they are taking the advantage of internet for their nefarious purposes. Friends, it is not as if the problems of porn have not been faced, have not been discussed at international fora. It is not as if the countries have not tried their best. It is not as if the countries have not tried to come together. The US, for example, came up with something called a CDA, the Communication Decency Act, which attempted to restrict the attempt by minors to, quote unquote, patent to obtain patently offensive descriptions of sexual or excretory activity. See the definition in the act. The aim of the act is to prevent minors. It is only dealing with minors, that people under 18 should not have access to such kind of material, and they should not have access to patently offensive descriptions of sexual or excretory activities. This applies to material in hard copy form, and this also applies to material over interactive computer service. So interactive computer service, this definition is wide enough to cover the internet, friends. Interactive computer service. Internet is interactive. It is, if it is not interactive, then there is nothing which is interactive. Internet, the very foundation is it is interactive, it is democratic. So friends, the US has a very liberal constitutional scheme like ours. Freedom of speech is protected under the First Amendment. And in the First Amendment it says that the speech which is not obscene but it is merely indecent. See these words, indecent and obscene. Something which is not obscene but merely indecent is going to be protected as free speech under the ambit of the First Amendment of the US Constitution. So friends, now I previously discussed with you that obscenity, vulgarity, they are very, very nebulous terms, they are very, very subjective terms. Now this term indecent is even more subjective. Now what is decency? So if obscenity itself is very, very subjective kind of a term, then what about indecency? That is to be interpreted by each person according to his how he has been brought up or how she has been brought up, what are his experiences growing up in life, etc. So, friends, the act was sought to be used, this particular act, the CDA, was sought to be used in a case in the US to apply to pornography. But unfortunately, the Supreme Court of the United States, by a majority of 7:2, struck down the attempt, and they said that no, the CDA cannot prohibit indecent speech. CDA applies only to the speech which is obscene. Speech which is merely indecent but not obscene cannot be prohibited by the CDA because it is enjoying protection under the First Amendment. So, like in India, in US, in every other country, the Constitution is the supreme law. You cannot make any other law which is in violation of the Constitution. Such a law will be struck down as being the violative of the Constitution, will become ultra vires. So, the CDA, which attempted to restrict the minors to have access to such material. The teeth of the CDA were severely curtailed by this particular judgment. Friends, as you may be knowing that in the United States, the entire Supreme Court, that is one Chief Justice plus 8 associate justices, they sit together and decide every case, unlike in India wherein you have benches of 2 or 3 or 5 or 6 or 7 or 9, whatever, to decide cases. The typical bench strength in India is 2 or 3 judges, except when there is a full bench or a constitution bench. So, in the US, all the cases are heard by a bench of 9 judges, which is the Chief Justice and all 8 associate justices. So, the name of the case, friends, is ACLU, Association for Civil Liberties Union versus Renault, and the year is 1997. Immediately after this law was brought in, the law was immediately curtailed by the United States, saying that no, you can't do this. You cannot curb distasteful, indecent behavior, especially if it is not obscene. So, because this is protected by the Constitution itself. So, this is again a case where free speech and expression has prevailed over a serious problem. So, like we were discussing in one of the previous lectures, it may be necessary to curtail the freedom of speech and expression in certain cases if it is damaging the society, if it is damaging the country. Previously, I have explained to you in the context of privacy, in the context of national security. Friends, Canada has attempted to take a similar approach. They set up in 1994 the Information Highway Advisory Council. See what a beautiful name, the IHAC, the International Highway, Information Highway Advisory Council, I beg your pardon, Information Highway Advisory Council. They are calling the internet an information highway. Just as we have expressways and express highways, they are calling the internet an information highway, and they set up this authority in 1994 to undertake a comprehensive study and prepare an official statement as to what was the position of the Canadian government, what was the position of the Canadian state on what direction the internet should take. When the IHAC studied this, came up with its report, issued guidelines. The guidelines are still not, they are very generic, they are nebulous, but they have come up with 2 very clear things, that hate speech and obscenity. Racist material, hate speech and obscenity. These are the 2 things which they say that they are the 2 main areas where regulation must start, and pursuant to this, Canada started regulating these areas from 2001 onwards, friends. Friends, talking about UK, now our legal architecture is by and large based on the experience of United Kingdom, because we are a country which is following the common law legal system. So, the position in UK is of great interest to us. The Obscene Publications Act of 1959, the Obscene Publication Act of 1964, both of them, they did not have any mention of the pornography or cyber pornography. Because friends, where in 1959 or 1964 was pornography in existence? It was not the cyber pornography in existence. Pornography was in existence, but like I said, the spread was very limited, because in those days, since you had to only circulate by printing or by coming out with books, etc., it is very expensive. It is not the cost of disseminating the information is very different, very difficult. If even to students, if you ask them to study an original text which is running into hundreds, thousands of rupees, most students will not prefer to buy the book. Rather, they will simply prefer to photocopy a couple of relevant chapters from the library or from some photocopy shop. That is the ground reality that you have. So the books, the market is limited, because people are not willing to spend that much of money, and whereas in internet the cost is a fraction cost, and internet is disseminating to large number of users, and thereby they are making large amount of profit. The per unit profit, you can also bring it down if you have large number of users. Same logic, like when mobile phones came, the incoming calls were being charged at 16 rupees a minute. Today everything is free. Data is free, calling is free, incoming is free, so STD is free. So because the number of users has gone up manifold. So same logic works with the cyber porn industry. Friends, the situation changed in 1994 with the amendment that was made to these Obscene Publications Acts, and but the amendment was made by virtue of Criminal Justice and Public Order Act, and this act had a definition whereby it was, see the definition please, it was covering material which has the effect of depraving and corrupting. Depraving and corrupting. Now these words are again very subjective, but at least it is an improvement over obscenity. It is an improvement over indecency. So these words, depraving and corrupting, and our law also uses the word deprave. So our IPC also uses the word deprave, our IT Act also uses this word deprave. Corruption is also mentioned. This corruption is not the other corruption that we know, monetary corruption. No, this is corruption of the values of the individual. So this word also we are using in our BNS and our IT Act. So friends, now what is the substantive law governing obscenity in India? Friends, this very word in Indian law is a legacy of the law of Britain, the colonial masters. Friends, there was a law, there was a case, Regina versus Hicklin. Regina is Latin for queen. Regina versus Hicklin. That was a case of 1868. Friends, that is 156 years ago. In Hicklin, there was a test which was evolved. The Queen's Bench was asked to examine a particular pamphlet and determine whether it fulfilled the test of obscenity. If it fulfilled the test of obscenity, then criminal action was required to be taken against the perpetrator of the activity, the printer, the publisher, the author. Friends, the test of obscenity which was evolved by the Queen's Bench way back as 156 years ago is this: whether there is tendency of the matter charged as obscene, whether such matter which is deemed to be obscene, whether it is sufficient enough to deprave and corrupt. See these words: deprave and corrupt. Deprave and corrupt. So the point I am trying to make is something which was laid down 156 years ago has been followed in UK till today, and the same thing we are following in India till today. Deprave and corrupt those minds who are open to such immoral influences and who may lay their hands on such publication. So publication the definition of publication is enough to include books, internet publication, pamphlets, etc. Of course, at that time publication meant publication of the book or pamphlet. So, let us look at the key ingredients of this test, friends. Whether the matter is sufficient to deprave and corrupt, not or, and corrupt those people whose minds are open to such immoral influences, and those who may have access, who may lay their hands to such publication. So, 5 ingredients of them. First of all, whether it was sufficient to deprave and corrupt those whose minds are open to such immoral influences and those who have the opportunity to lay their hands on such publication. So, this can be called the 6th thing. It must be a publication. It must not be just an abstract idea. It should be a publication, a communication. So, these can be called the ingredients of Hicklin. Friends, we had a case in India, the case of Ranjit Udeshi versus the state of Maharashtra. The matter went up to the Supreme Court. The incident took place in the 1950s. There was a bookseller in South Bombay where there are lots of colleges, offices, etc. This bookseller, Ranjit Udeshi, he was selling various books, and some of the books which were being sold by him contained what was deemed to be obscene matter. He had a novel called Lady Chatterley's Lover. He had this book, Lady Chatterley's Lover. The police seized these books. He had the various copies of this book. The police seized these books. He took the plea when he was being prosecuted before the trial court, before the High Court, before the Supreme Court. He has taken the plea that, look, I am selling hundreds of books, thousands of books. First of all, I am not facile with the English language, and secondly, I don't have the time. I am earning my daily bread. I don't have my time to go and look into the content of each book. Some distributor has brought me a book. I am selling it. I am trying to earn my daily bread. Friends, all the courts right up to the Supreme Court have refused his defense and said that you must be responsible for what you are selling. What you are selling, if it contains something wrong, then you are responsible for it. So, while doing so, the Supreme Court has said that we have to operate, Indian judiciary has to operate within the law which was laid by the Queen's Bench in the case of Hicklin. Hicklin was announced in 1868. This is a judgment of 1965. So, they say we will follow the same policy which is laid down 100 years ago. Now, friends, another 56 years have passed. Another 35 and 24, 59 years have passed. So, 156-year-old policy. Friends, the nature of obscenity changes over time. It is very fluid, and thus it is very important for Indian courts to evolve their own standards and not just go by what a foreign court has decided, a UK court has decided 156 years ago. Hicklin was decided in 1868, friends. We are now in 2024. Friends, it will probably be more important at this stage to refer to the case of the Bandit Queen case of Bobby Art International versus Ompal Singh Hoon, to look at the law in India governing obscenity. Now, this was a case wherein the late Phulan Devi, who was earlier a bandit in the ravines of Chambal, the area in Madhya Pradesh and Uttar Pradesh. That area, which is most of it is actually in Madhya Pradesh, some of it is in Rajasthan also, Dholpur. Morena part is Madhya Pradesh. So, this movie was made by the producer Shekhar Kapoor on the life of Phulan Devi. Now they have shown the life of Pulan Devi in a manner which she took objection to, that in real life unfortunately she was a victim of rape, and which actually, and oppression by the people, certain people, landlords, etc., and which made her become a bandit. And this movie was supposed to be based on her life. It was supposed to be a biography of hers. But in the movie, there are the rape scenes, etc., shown in a very obscene manner. There is large amount of portion which is shown which is not conducive to the Indian audience, and accordingly the censors gave an adult certificate and ordered several cuts even while giving the adult certificate. So immediately Pulan Devi first approached the censors and then the court, that whether such kind of a thing can be allowed, and in this, and finally the court has given certain guidelines on obscenity. Unfortunately, they are not very different from what they have decided in Ranjit Udeshi, but yes, some movement has been made. Friends, there is another case that we can talk about when we are discussing the position of obscenity in Indian law. That is the case of Maqbool Fida Hussain. The late painter, very famous painter, Maqbool Fida Hussain, he went and painted certain goddesses in the nude, and he argued for artistic freedom under 19(1)(a). The court says that you do not have a right to commit obscenity, and you do not have a right to commit to hurt people's religious sentiments. Friends, the aspect of obscenity has been evoked in other cases also. There was somebody who, the cartoonist, who drew a cartoon saying that Parliament is a giant toilet and somebody is urinating on the building of Parliament. So there also action was taken, and of course he was prosecuted for sedition. Whether that is correct or not is not the subject of this topic, but talking about obscenity, the courts have said that urinating in public itself, an act showing somebody urinating in public itself may amount to obscenity. But again, critics argue that such judgment may be stretching the envelope, pushing the envelope too far, because it may not be obscenity per se if somebody is just trying to make a point by making a caricature and not an actual drawing of urination. Actual drawing of urination certainly, but whether a caricature of urination will also tantamount to the obscenity, the question remains, there is debate on that. So, friends, both making the porn available and possession, making it available, creating it, all of this, creation of porn, available, circulation of porn, possession of porn, these are all offences. And like I mentioned before, the deprave and corrupt, these are both the same words which have been used in UK. These are the same words which have been used in R versus Hicklin. These are the words which we are still using in our Bharatiya Nyaya Sanhita. These are rather subjective terms, and that is why there are these questions about how the pornography, cyber pornography is to be controlled, tackled. Friends, let us now look at our legal infrastructure in terms of the Information Technology Act. There are three principal sections: Section 67, which was there in the original Information Technology Act, and Section 67A and B, which have been introduced by amendment. So 67 deals with punishment for publishing and transmitting the obscene material in electronic form, whereas 67A deals with transmitting or publishing such information if it is information concerning showing a sexually explicit act, people engaged in sex. Remember, making cartoons who are indulging in sex, or making avatars who are indulging in sex and showing it, is also coming within this purview of cyber pornography, this particular section. Then friends, you have 67B, which is the provision which is dealing with even more specific, showing children involved in sexually explicit activities. So let us look at these three provisions one by one. So section 67 provides for information for any person who is publishing or transmitting the obscene material in electronic form. The purpose is to punish such person who is publishing or transmitting or causing to be published the such obscene material in electronic form. And any material which is lascivious, or see, this is now a new word, lascivious or appeals to the prurient interest. At least these words are better, they are more objective than these words which have been previously used. So as compared to these words which are now being used in the Information Technology Act, at least this is an improvement. These words are more subjective, less subjective and more objective as compares to the words of deprave and corrupt. So or any person who is creating or sending or transmitting such material which is lascivious or appeals to prurient interest, or effect is such that it tends to deprave and corrupt persons. Same words as used in BNS, same words as used in HICLIN, same words as used in the UK Act. Those who are likely to having regard to the relevant circumstances to read, see or hear the matter connected or contained or embodied in such material. These are the words which are again coming from HICLIN, which is 156 years old. Then punishment for the first conviction is fine of 5 lakh and jail of either description, with simple imprisonment or rigorous imprisonment of 3 years. Second or subsequent conviction, the imprisonment will can go up to 5 years and the fine can go up to 10 lakh instead of 5 lakhs. Friends, now coming to the next provision which we have, which is section 67A of the Information Technology Act. It provides for punishment for publishing or transmitting the material containing sexually explicit. This is the addition as compared to the previous section, in electronic form. Any material which is showing a sexually explicit act, people indulging in any kind of sexual activity, sexual gratification, whether it is physical sex, oral sex, whatever. If you are going to be showing that on as porn, it is going to be punishable under 67A. So the punishment is also going to be higher because the offence is more serious. You are showing something in sexually explicit form. So any person who publishes or transmitted or causes to publish or transmit in electronic form such material which is sexually explicit act or conduct, first conviction 5 years punishment, 10 lakh fine, and second the 7 years punishment and 10 lakh fine. Friends, in the Information Technology Act, the maximum limit of fine which has been imposed is 10 lakh. So there is nothing more than 10 lakhs. You will find even for cyber terrorism it is this much only. Friends, moving further, this is an even more serious offence. So you see the jail term 3 and 5 years, here it is 5 and 7 years, and here again you will find, here again you will find 5 and 7 years. And so this is, now you are showing one of the most serious kinds of porn which is involving children, minors. Either the minors are indulging in sexual activity or the minors are indulging in sexual activity with adults. So which of them is worse, I don't know, but both of them are really, really bad. So the punishment for publishing and transmitting, publishing or transmitting the material depicting children in sexually explicit act, any person who is publishing or transmitting or causing to be published or transmitted material in electronic form which shows the children engaged in sexually explicit act or conduct will be responsible under this provision. And if he is creating or sending the text or digital images, or is collecting, seeking or browsing, downloading, advertising, promoting or exchanging, distributing material in any electronic form showing the children in obscene or indecent or sexually explicit manner, if he is showing children, he is responsible. Or if he is cultivating, enticing, inviting, inducing children into any online sexual relationship with another child, or with adult or sexually explicit, or to commit with a child any sexually explicit act in a manner that is offending any computer user. Any computer user gets offended seeing what is happening. He is enticing or inducing the children to online sexual relationship with one or more children or adult, or committing sexually explicit act in a manner that may affect the reasonable adult using the computer. Then also he is coming within the purview of this offense. He is facilitating abusing of children online. Let's say somebody is arranging for children to be sent to a place where they are going to be abused. He is taking part in such online transaction. Even then he will be punishable under this section. And or if he is recording any abuse of children, let's say somebody goes and records some child is being abused somewhere, and another person takes out his mobile phone and starts recording it. Even then he is punishable under this section, because he is, for his own enjoyment or for his own records or for use later, he is creating this electronic record, whether he has himself abused a child and recorded, whether somebody else is abusing the child, or somebody is performing sexually explicit act with a child. If the person is recording, then he or she will be punishable under this section. The first conviction involves the jail term of up to 5 years, and fine is there up to rupees 10 lakh. The second or subsequent convictions involve the jail term up to 7 years, and fine is again up to 10 lakh. So, friends, there is a proviso to sections, to proviso to this particular section 67B, which mentions that the provisions of section 67, the provision of section 67A and the provision of section 67B will not apply in the case there is any book or any pamphlet or paper or writing or document or painting or representation or figure in electronic form, provided the publication of such painting or book or pamphlet or paper or figure is required, it is justified in public interest, for public good, on the ground that it is in the interest of, such publication is in the interest of the science, literature or other objects of general concern. So, for example, if somebody has made a reproduction of the art which is on the walls in Khajuraho. So, that is our archaeology, that is our something which is there in our culture. So, then reproduction of that is not going to be coming within the definition of the section 67, 67A or 67B, friends. So, similarly, such book, the pamphlet, paper, writing, drawing, painting, figure or representation, if it is kept for bona fide heritage or religious purposes. If it is for heritage purposes, religious purposes, or if it is in the interest of public good, or if it is in the interest of science, literature, art or learning, then you have an exemption. What is the definition of children? For the purpose of 67B, children is any person who is below the age of 18 years. Friends, the diffuse nature, internet is not concentrated at one place. So, the problem is also not concentrated at one place. The diffuse nature of the problem of cyber porn is makes it very difficult to tackle. The approach emanating only from positivist law will not always succeed. So, what is positivist law? If you remember from your jurisprudence class, law is the command of the sovereign. So, the sovereign, the state, by command itself will not be able to tackle the problems which the internet poses. It is very important to look into the concept of governance of internet rather than government of for the internet. Governance of internet is required, not government for internet. So, this when we talk about governance of internet, it does not require any single hierarchical impositionary structure, one single structure whereby, like we have in the traditional government, that is not required. Instead, a hybrid paradigm of governance wherein there are multiplicity of actors. That is what is required. You need international cooperation, you need private sector participation, you need to sensitize the public, you need to educate industry. That is how people will be able to solve. Just by the command approach which works in positivist systems, this problem may not be solved. Friends, norms and values keep evolving and the importance is there for freedom of speech and expression, no doubt, but at the same time we need to ensure that cyber porn is checked. Entire generations get spoiled, friends, and that is what is very sad. While freedom of speech and expression is a cherished value, but freedom of speech and expression should not be allowed to come in the way of checking the scourge of cyber porn. There is no other way to describe it. It is a scourge. It is a major problem. As per the Bharatiya Nyaya Sanhita and as per the Information Technology Act, anyone within the country who carries on the business of cyber porn is liable. Just as the case of Ranjit Udeshi, wherein a bookseller is liable for the books which he is selling. Just as video parlors are liable for the illicit content which may be there on any video which they are renting out. So just as any person who is selling DVDs is responsible for any of the illicit content. He has not seen all the DVDs, but if he is selling, if he is renting, he must know what is the content, and if it is something illegal, he is responsible for it, friends. So both BNS and the IT Act, section 67, 67A and 67B make it clear. 294 of BNS also is on the same lines. Friends, the case of Dr. Prakash versus State of Tamil Nadu, the Supreme Court of India has said that while interpreting section 67 of the Information Technology Act, the court may exercise its powers in the interest of contemporary society, the society which prevails, which exists at that point of time. And you must ensure, the court has the power to ensure that the influence of obscene material in electronic form is not felt on society as a whole. So we have to take a holistic view of the whole problem and ensure that porn is not allowed to wreak havoc on the minds of young and old alike. When I say old, generally the old people are not the ones who are seeing this, it is the adults who are doing this. So both adults and children need to be protected from the scourge of cyber porn. So that brings us to the end of this lecture, friends. I hope you found this lecture useful, and we will now meet for the 10th lecture, which is the final lecture of this course, wherein we are going to be studying the problem regarding the software which is there on the internet and how we can protect it by existing laws. So thank you very much for your patience, friends. Look forward to meeting you in the next session.